Number 3. Some recent scholarly works on Grotius's account of property right have failed to elucidate adequately the relationship between natural laws and the institution of private property. This may have been occasioned, at least in part, by a faulty translation of some relevant passages. Bryant Tierney, for instance, explains Grotius' understanding of a transition from use right to property right in terms of a logical process, but he does not elucidate which process it is, nor in which sense it should be logical. The expression logical process appears in the English translation of De Jure Praede, where the Latin text reads ratione quadam, that is, a certain reason. John Salter, on the other hand, correctly affirms that for Grotius, the emergence of a property right somehow involves the use of reason. Nevertheless, he argues that an object that was seized without being immediately consumed becomes one's property if one indicates the intention to keep its possession for further use in the future. This can hardly explain how an object becomes someone's property. Suppose I rightfully occupy a piece of land. As long as I use it, no one is entitled to take it from me. Yet, I do not possess it. If I stop using it for some time, another party is entitled to occupy it, even if I have indicated that I intend to use it again later. If, on the other hand, I provide this piece of land with a fence, I am not indicating that I intend to use it later. I am simply preventing other persons from using it now. By erecting a fence around this piece of land, I am using it. That is, I am defending it against the prospective invaders. The fence by itself does not turn this piece of land into my private property unless other parties accept or recognize that I am its legitimate owner. And once others have recognized the piece of land as my private property, a boundary indicated, for instance, by a line of stones on the ground, can play the same role the fence does. Salter's interpretation may have been misguided by a faulty translation of the relevant passage at issue here, where Grotius affirms that for creatures other than irrational beasts, it is enough that the occupation, which began by means of some physical effort, be retained in the mind. In alis sufficient corpore, possessium animo interie. Salter relies on the following translation. It is sufficient if after physical possession is once taken, the intention to possess is maintained. What allows the transition from the mere occupation of an object to the legitimate property of the same object is not the unilateral intention to keep it, but the fact that an occupation, which begins by physical means, is later retained in the mind of all parties involved, as though the object in question were still being occupied by means of some physical effort. Another misleading translation in this regard consists in rendering non animi actu solo into not by a mere act of the will. This translation renders Grotius's argument almost unintelligible, for his thesis is that the existence of a property right depends on a kind of pact. But a pact, whether express or tacit, is an act of the will. If Grotius intended to attribute the origin of private property to some instance other than a mere act of will, it would be then unclear why he refers in the sequence of the text to a pact, in other words, to something that is actually an act of the will. Grotius' thesis, defended in De Jure Belli Act Pagis, that private property has its origin in a kind of pact, does not conflict with the thesis he has defended in De Jure Praede, according to which private property is in a certain sense, produced by reason, and retained in the mind. The allusion to the idea of a pact simply makes it clear that the mental act at issue in the creation of a property right is one of acceptance. This act is performed at a collective basis and can be comprehended as voluntary assent to the terms of a pact. There is indeed some textual evidence that suggests that, for Grotius, the collective acceptance or recognition that an object counts as one's property manifests itself mainly through tacit assent rather than through explicit assent. In De Jure Praede, Grotius affirms that the states were created by means of a sort of contract for the sake of mutual aid, At the beginning, the existence of a state depends more on the express assent than on the tacit assent of its founding members, but later the state comes to be sustained more and more by means of a tacit assent, as new members join the already founded political community. Accordingly, express assent plays a more important role in the inception of a political community, but later the individual's will to sustain the political community manifests itself mainly through tacit assent, because the state ultimately exists to guarantee the protection of private property. Tacitly assenting to the preservation of the state amounts to tacitly assenting to the preservation of the institution of private property. Number 4. In the modern tradition of the social contract, the figure of the contract is usually seen as an event, real or only hypothetical, that should put an end to the state of nature. Because Grotius, unlike, for instance, Thomas Hobbes or Immanuel Kant, conceived of the state of nature as a real state of affairs, he also conceived of the contract of 9 non-hypothetical terms. On the other hand, he did not defend the quite implausible thesis that a social contract would have taken place once and for all, and that, after this founding moment, civil society would have suddenly appeared. Grotius seems to have conceived of the overcoming of the state of nature as a gradual process that was mediated not by a single, but by many explicit and tacit contractual steps. In De Jure Praede, he affirms that, after the creation of private property, a law was posited, lex posita est, in order to ensure that the institution of private property would not be violated. Then boundaries were established, and in an ensuing step, commercium, was institutionalized. At this time, states, republicae, were also founded, as Grotius puts it in his 12th chapter of De Jure Praede. At a subsequent stage, after the establishment of private property, commerce began to be widely practiced. During the same period of time, moreover, the establishment of states was first undertaken. Social institutions, such as laws, boundaries, commerce, and the state, were created for the protection of the institution of private property, and private property in its turn ultimately presupposes the existence of a non-institutional entity, namely the natural right every individual has to avail herself of what has no owner. This last aspect of Grotius' theory evidently cannot be approached in institutionalist grounds, for Grotius commits himself to the quite problematic thesis that there are in the world not only physical objects and human institutions, but also things such as natural laws and natural rights. Grotius' commitment to these metaphysical entities notwithstanding, in De Jure Praede and in De Jure Belli ac Paris, an important step was undertaken toward an understanding of normative ideas such as law, property rights, boundaries, and the state in terms of man-made institutions. These institutions are collectively created and maintained in order to ensure that some very basic human needs and desires be satisfied. Among these elementary needs and desires is, for instance, the wish to protect one's own life, as well as the wish to be able to keep for oneself the objects that are crucial for the preservation of one's life. For this reason, Grotius argues that, in some special circumstances, one may be rightfully dispensed to respect the institution of private property if it proves to be the only reasonable means of preserving one's own life. As Grotius affirms in De Jure Belli ac Paris, in a case of absolute necessity, that antient right of using things as if they still remained common must revive and be in full force. For in all laws of human institution, and consequently in that of property too, such cases seem to be accepted. If I am starving to death and another individual possesses an apple, I may rightfully take, or try to take it from him or her, for I tacitly assent to the existence of the institution of private property only to the extent that I also recognize that this institution helps me to fulfill, in joint work with other individuals, some basic needs we all have, but in cases of severe necessity, the institution of private property may fail to fulfill the original function in virtue of which it was created in the first instance. For this reason, in these circumstances, I do not have a reason to behave towards the apple as though it were already part of the substance of the person who happens to be holding it in his or her hand now. I consider the apple rather as a common object, as something to which the other individual and I have an equal legitimate claim. Grotius goes as far as to affirm that, if a case of severe necessity affects only one of the parties, then the other has a duty to give the apple not for the sake of a rule of charity, but for the sake of one's right to preserve one's own life. A natural right, such as the right to preserve one's own life, therefore overrules any property rights. For Grotius, any individual has a legitimate claim to whatever is necessary for the preservation of his or her own life. This claim, however, is not the simple expression of a wish to preserve his or her own life. This claim is rather a right, just, for it is already a moral significance. It has already a moral significance. Indeed, a right, in the proper sense of the word, jus propriaut stricto dictum, is, according to Grotius, a moral quality of the person. But are there really any natural rights? At this decisive point, Grotius conflates the concepts of rights and interest. His reason for defining subjective rights in terms of the most elementary demands any human being can reasonably make, as Richard Tuck has shown, was to oppose skepticism. The skeptic could rightfully allege that it is by no means evident that he himself was endowed with a natural inclination toward the well-being of other individuals, nor that he was subjected to a natural divine law that enjoined him to care for the interest of his fellow men as much as he cared for his own interest. But could the skeptic reasonably doubt that he had an inclination toward his own well-being, or that he cared for his own interest, even admitting that he did not have any concern for the interest of his fellow men? This apparently could not be denied by the skeptic. Thus Grotius' methodological strategy against the skeptic consisted in calling attention to the proposition that could be taken as immune to the skeptical onslaught, namely, that every individual has an intrinsic interest in the promotion of his or her own well-being, and only secondarily also an interest in the well-being of other individuals. This thesis seems so unquestionable that Grotius considers it a law of nature, albeit a law of nature quite different from the laws of nature that pre-modern thinkers such as Cicero or Thomas Aquinas had in mind when they employed this expression. But the conceptual problem remains. Having an interest is not the same thing as having a right, unless some further reason is adduced for us to behave toward the interest of other persons as though their interests were not just the expression of a wish, but a right, a legitimate claim backed by moral reasons. In this respect, Jeremy Bentham saw with paramount clarity that the advocates of natural rights confounded the concept of interest with the concept of right. Bentham's point was that, no matter how reasonable an interest may be, an interest, taken by itself, is neither a right nor a moral claim of any sort, but just a wish that a certain state of affairs obtains. Even the basic interest to preserve one's own life, or the interest to be able to use without interference what has no owner, is not in itself a kind of right, but at most a reason to create an institution in the context of which this wish might acquire a new status, namely, to become an individual right. As Bentham puts it, rights are, then, the fruits of law, and of the law alone. There are no rights without law, no rights contrary to the law, no rights interior to the law. Before the existence of laws, there may be reasons for wishing that there were laws, and doubtless such reasons cannot be wanting, and those of the strongest kind. But a reason for wishing that we possess a right does not constitute a right. To confound the existence of reason for wishing that we possessed a right with the existence of the right itself is to confound the existence of want with the means of relieving it. It is the same as if one should say, everybody is subject to hunger, therefore everybody has something to eat. Even though Grotius did not go as far as to argue, as Bentham did, that the existence of any rights presupposes the existence of human institutions in grounding morality in the most basic claims any individual can reasonably raise, Grotius, in a certain sense, paved the way for a more secular comprehension of normative ideas, such as property rights in terms of man-made artifacts. If this interpretation is correct, then Grotius should be seen as predecessor rather than an opponent of Bentham.